Okay, so earlier in the course we talked about how the juvenile justice system as a whole is a state-run organization. It operates by the states, for the states, kind of at the pleasure of the states. The federal government really has limited impact or power, let's say, on the juvenile justice system as a whole. But this doesn't say that the federal government doesn't get involved in it, because as we've seen in various other ways, even when there's no constitutional authority for the federal government to get involved, there are still ways for them to kind of stick their hand in, maybe ensure a fair, even playing field for everybody. Obviously, the first way that they get involved, and probably the one we see the most, is at the judicial level. Juvenile justice cases can still go to the Supreme Court, and they get ruled on a constitutional basis. And though we've limited some of those constitutional rights, we still have them to a point. So, if we look at the federal government's involvement, we see the judicial. And SCOTUS is probably the biggest thing we see there. There are also other levels of federal appeals, but that is not quite as big or as known of an issue as the stuff that hits the Supreme Court. So we see the Supreme Court take on cases of the juvenile justice system that would be a way that the federal government gets involved, and a way that's really constitutionally permitted for the federal government to get involved. But see, there's another way they can get involved, and that is legislative. But you say, wait, now Bruce, earlier you said that there's no constitutional authority for the government, or Congress, the legislature, to get involved in the juvenile justice system. And, well, you're right, there is no constitutional authority. But they still create laws that impact the juvenile justice system. They're not creating a law and mandating that law gets followed by every state, but they essentially create guidelines. And we'll talk a little bit later about why and how, and even what states choose to comply with this legislation. The biggest piece of legislation that we see is Jjdpa. Now you see this a lot in your text. It talks about it. You'll see me bring it up a lot. This is an important thing. It really drives the way our juvenile justice system operates. And it stands for juvenile justice, and delinquency prevention Act. This was first put out in 1974, and we'll talk about what its main purposes was from back in 1974, the reason that Congress kind of felt they needed to get involved. But it's also important to note that this was reauthorized again in 1980 and again in 2002. Not as much here, not as much in 2002. Some pretty big things here in 1980. So we'll talk about what those big things were as we kind of go through what Jjdpa actually does. So if we look at Jjdpa, what exactly does it do? Well, it does a number of things. First of all, number one, and probably most importantly, is it creates funding creates funding for the different states to receive for their juvenile justice programs. Most commonly does this in the form of block grants. And I won't get into detail about what exactly block grants are, but suffice to say, block grants are a way that the federal government can provide grants to different states. So that's the other thing it does. Number two, it creates OJJDP. OJJDP, the Office of Juvenile Justice and Delinquency Prevention. The number one reason to kind of have this this Office of Juvenile Justice Delinquency Prevention, we'll call this point A, is to distribute funding. Because what you'll kind of learn about block grants, and it depends on whether you take, what kind of government courses and stuff you take. What you'll kind of learn about block grants is that they require specific things to occur for them to exist. So OJGDP develops the criteria for those block grants and then goes ahead and distributes them accordingly. And then we'll say point B is for research. And you'll see that there are several research pieces out there that are funded or backed or contributed to by OJJDP. You'll actually see it in your first week's assignment. You'll see that that juvenile justice bulletin, that's actually backed and funded by OJJDP. So that is kind of a predecessor that exists because of the Juvenile Justice Delinquency Prevention Act. And then the third thing it does, and we'll go into more detail here, is it creates key initiatives, is what we're going to call them. And these key initiatives are things that they essentially put in to JJDPA to protect youth. So let's talk about these initiatives, key initiatives. Okay, so key initiative number 1. Deinstitutionalization of status offenders. And this is the reason, first of all, for the most part, these first two key initiatives are kind of the primary reason why JJDPA was created. These were the things that people were concerned about, that Congress was concerned about when they developed the act. Deinstitutionalization of status offenders is essentially decriminalizing status offenses. Before, status offenses were criminal offenses, and these status offenses that we talked about earlier, we know how to differentiate the difference between the status offenses and delinquent offenses. These are offenses that adults can't commit. And these carried with them often some very harsh punishments. I mean, people would skip school and go to jail, go to prison, spend hard time because they skipped school or because they were smoking cigarettes or because they ran away from home. And what we realized through the research is that this is not a good idea. It doesn't help, particularly when you take these minor offenses, put them in with major offenses. I think what we learned, the basic way to put it is, if you take a minor offense and breed it with a major offense, or people who create major offenses, you more than likely are going to come out with more major offenses. So we realized that when we put these juveniles in detention or any type of facility, really, that we increase their likelihood of committing more delinquent acts. So we deinstitutionalize status offenders. This is the provision that does not allow incarceration of status offenders. If you arrest somebody for smoking cigarettes, you're not going to be able to incarcerate them. There are a couple of exceptions to that. We'll talk about that as we move on. But for the most part, consider that if it's a status offense, they're not getting incarcerated. They're not going to jail. It's not good for them anyway. This just kind of provides that. Number 2 is sight and sound separation. Oops. So sight and sound separation is really exactly what it says. It is the fact that we have to remove juveniles from anywhere where they are within sight and sound of adults. And you'll see this really at any stage of the justice system. You'll see this in the court levels. You'll see this in the jail levels. You'll see this in the processing facility levels. And this is much harder to accomplish, obviously, as you would think, in bigger cities than in smaller cities. Consider New York. I'm not sure if we have anybody in class that works in one of these big, huge metropolises, but we often don't have the ability to easily separate juveniles from adults without making some pretty major concessions. And that has to be done according to Jjdpa. In smaller cities, though, like take my city for example, it's rare if we have more than 1 or 2 people processed through our jail or our booking facility each day. It just doesn't happen all that often that we get more than that. So the reality of it is that every time I've taken a juvenile back there to process, they've automatically been separated because we haven't had adults. We don't hold people in our facility. We take them to the county jail, but we do process them in our facility. So, we don't often have to worry about it, but occasionally it does come up to a point where we have to keep them completely isolated, and that usually takes an extra officer. So that's something that we have to kind of think about. So these two things were 1974 edicts. These came from the original Jjdpa in 1974. Item number 3 is jail removal. And we created this on the bill's reauthorization in 1980. Where we essentially added a new line to Jjdpa and said, listen, not only are we going to keep them separated by sight and sound, but we're going to remove juveniles when at all possible from adult jails, from adult booking facilities. Really, anytime we can possibly remove them from the adult atmosphere at all, we're going to do that. And we do that in an effort, once again, to reduce labeling theory or social learning theory, lots of different things in there. But this was something that came about in 1980. Also in 1980, along with this jail removal, we developed what we call the valid court order rule. So here's what the valid court order exception did. And this applies, I don't know how to draw this. This applies to DSO. The valid court order rule says that if a valid court order has been violated, the offense is no longer a status offense. It then becomes contempt of court, which is a misdemeanor. And this valid court order is almost a loophole to be able to incarcerate certain people based on this idea that they violated a court order. Now, we'll talk about this a little later in more detail, but just get the idea that, right now, a valid court order being issued, maybe a probation violation, something like that, can kind of trump the deinstitutionalization of status offenders. The last kind of major thing that we have in Jjdpa is disproportionate minority contact, DMC. And this was a 1982 edition when it was reauthorized. Or, I'm sorry, 1992 edition. I just totally did that wrong when you guys cross this out. So, essentially this is, and what you kind of read in your first assignment was that we do occasionally have a higher proportion of minority demographics contact than we have of non-minority demographics contact. So what this established was a requirement that states do something to attempt to fix this. And it may be, we may find out it's impossible to fix this. But what the act actually says is that you need to make an effort. And the effort is, for the most part, going to be good enough to comply with the law. But that leads us to another, so that kind of leaves us with the question of why comply. So why should states comply? So let's think about this a little bit. Like we said, there's no constitutional authority granted to the federal government to operate a juvenile justice system. So why exactly should the states comply? Well, easy. Well, it seems easy. The big answer: block grants. In order for states to receive their block grants, they need to comply. And there's a formula. Formula block grants. There's a formula that states that don't comply reduce by a certain percentage the amount of grants they're eligible for. That gets in. That's a political issue. We'll kind of keep away from that. But the idea is that if you don't comply with those four main requirements, then you're not going to receive all your block grants, or maybe you don't receive any of your block grants. We'll find one state that actually does that. So, how do we determine who is complying and who is not complying? Well, the reality of it is that we actually have 9 states that aren't complying in some way, shape, or form. And what you'll find, and this is just a little kind of an interesting piece of information, if you look at states down south, the states in the south tend to comply less with this government edict than the states in the north. And some of the most kind of out there examples of not complying come from states in the south, particularly Mississippi, which it not only is it one of the poorer areas of the country in terms of capital, but they also kind of do a lot of things that don't follow Jjdpa. So then they lose some of their federal funding because of that. So let's talk about who doesn't comply. Now, the idea here is that this is really a carrot and a stick kind of thing. You know, hey, you follow this rule, we're going to give you some money. So, states that don't comply: Arkansas. Arkansas does not comply with DSO or jail removal. Mississippi does also not comply with DSO or jail removal. North Carolina with DSO. South Carolina with jail removal. Washington, that's Washington State, not Washington, D.C., does not comply with DSO. And then the last three that we have, they're not really states. The Virgin Islands, Puerto Rico, PR, and American Samoa also don't comply. I believe Virgin Islands, it's the status offenses. With Puerto Rico, it's sight and sound separation and jail removal, and with American Samoa, it's disproportionate minority contact. So we'll see that, you know, not every state chooses to comply, but really there's one more thing to add here, and that's Wyoming. Here's an interesting tidbit of information. If you remember back from my first little presentation, I talked about Wyoming having that 19-year-old age requirement. You know, they treat juveniles all the way up to 19. Here's the other thing. They don't comply. Actually, you know what? That's a bad word. I'm not going to say that. We're going to say they don't participate in Jjdpa. They don't participate at all. They don't receive block grants. They don't receive any of the financial block grants or the financial grants or the program grants that come from Jjdpa in Wyoming. They also don't typically comply with the edicts put forth in Jjdpa. So something to kind of consider as you look. Now, so that kind of answers why comply. So let's step back a little bit and look at that valid court order exception. Now, this was put in, remember, back in 1980. And this is probably the one thing that people are driving harder to get removed from Jjdpa than anything. So essentially, a valid court order, you can hold a status offender. So let's talk about some of the big ones. Probation violation. Probation violation. So let's say you run away from mom and dad, and the judge places you on probation and says you can't run away from mom and dad again as part of your probation. But then you run away from mom and dad. Well, now it's a probation violation. You can go to jail. That being said, maybe not the smartest move on the kid's part, knowing that he could go to jail, but still, it was there. The other thing is, let's say you're on probation for something else. I mean, say you're on probation for stealing money from your aunt or whatever, and then you get caught smoking cigarettes. Well, that's probably a probation violation. You can go to jail. I've seen, in my personal experience, some rather interesting probation violations get charged to kids. One of them, probably the most interesting, was a kid that he was on probation. I believe it was for drugs, and it wasn't like selling drugs or anything like that. I think he had some marijuana on him. So he was on probation for a relatively minor offense. He did spend some time in detention on the drug charge, but he was released back on probation, and his school had a rule about wearing hoodie sweatshirts. Students weren't allowed to wear hoodies to school. He wore a hoodie to school, and the teacher called his probation officer, and the probation officer came and arrested him and brought him back to jail. So there's a status offense right there. Probably the lowest of the totem pole status offenses that you can get. You went to school with a hoodie sweatshirt on, and you ended up in jail because of it. So that's kind of the number one valid court order that we see all the time, is that probation violation. But why was this valid court order thing actually put in there? Well, see, it was really put in there to protect neglected, runaway, and other juveniles. And I'm kind of taking these words right out of Jjdpa. Other juveniles in need of supervision. It's built to create a way to hold these people that kind of need to be held. Research kind of shows that we do run into some things every once in a while where we need to hold these people, and a valid court order can hold them. And that's one thing is to realize is that sometimes a valid court order does not come in the spot of a violation. It can also be an order to hold. The order to hold a little more limited in what it can do. Essentially, you're talking about a pre-hearing detention. It's limited to 24 hours of judicial days. So essentially, if you get a judge that gets called on a Friday night and he issues a court order to hold for a juvenile, that kid's 24-hour clock doesn't start till Monday. So you're talking about 24 hours of judicial days. And then they have to go in front of a judge before it goes any farther. But that's kind of what that's for, is that juveniles in need of supervision. There's lots of things there. But here's what we found. We tend now to incarcerate about 400,000 status offenders a year in the United States, which is about double than what it was between 85 and like 2004. So in 2004, we incarcerated roughly 400,000 status offenders. Now in 1985, when we first implemented this valid court order rule, we incarcerated about 200,000. So you can see that number keeps increasing and increasing, and we see this being used as a loophole more and more and more as we go forward. So one of the things as we look at reauthorization, because the reality of Jjdpa is that it has been quite some time since it's been reauthorized. So the things we look at about reauthorization is to complete removal, from adult jails, We're looking at strengthening that provision. They're also looking at strengthening the DSO provision. They're also looking, and this is kind of the big one, at eliminating the valid court order exception. It's actually appeared, they've been trying to reauthorize this act for, I don't know, maybe 5-6 years now, and we've had other stuff going on that's prevented it from getting reauthorized. It still exists. It's not a sunshine law. It's still in place, but they want to update it. And obviously we have some economic things going on in our country, and other things have kind of taken center stage. It hasn't gotten reauthorized, but they are looking at, in the reauthorization, eliminating the valid court order exception, meaning there will be nothing there to be able to incarcerate status offenders. I think you can look at this as a good and a bad. There may be some times when you need a valid court order exception. I can think of an instance where we had a kid that ran away several times from dad, and our judge here, our juvenile judge, didn't want to use the valid court order exception on him. Well, a couple times he made it all the way down to Tennessee, and I live, about halfway up the state in Ohio. I live about halfway up the state on Interstate 75. So he traveled all the way down 75 from about the midpoint in Ohio to Tennessee. The second time he went down, he made it all the way to Georgia, and he was running away to go live with his mom. He was moved from Georgia to Ohio to be with his dad by the courts because his mom was using drugs. Well, obviously, mom probably let him get away with more things than dad, so he wanted to come back up here. But we utilized a lot of resources, and departments in between Ohio and Georgia utilized a lot of resources to track him down 5 or 6 times before finally a valid court order was issued, and he was held until we could figure out a solution. So, the other thing that we're looking at is strengthening the disproportionate minority contact rule, and even more so is figuring out what is compliance. Does it require complete compliance? If we have one violation of sight and sound, does that mean they lose all their funding? There's lots of questions in there that the Office of Juvenile Justice Delinquency Prevention has been rather lenient with the compliance of Jjdpa, just because it's not written into the law exactly what compliance is. So they want to write into the law exactly what compliance is. So I hope that kind of gives you a better understanding of Jjdpa. Like I say, it's kind of an important foundation to our system. It's important to understand how it applies and the kinds of things it means to you guys working as practitioners.